red dot. Okay, legal issues. This is a lecture I first gave a few years ago over in the IT department, the School of IT. And this is the essential disclaimer at the start. I am not a lawyer. This is not legal advice. I say that because there are legal implications to giving legal advice, especially if you're not a lawyer. So what I'm trying to do here is to call out for you legal issues that you can run afoul of without necessarily realizing that's what you're doing. Just want you to be aware of this as you go out and work in the real world, because I read stories on a regular basis of IT people who find themselves embroiled in legal complications, sometimes, in some cases, facing criminal charges for things that they thought were okay or noble or whatever. 4 main areas of caution you need to be aware of working in IT. Unauthorized access of a system, and we're going to talk about in a minute just how broadly that can be defined. Intellectual property, misappropriation, infringement, and so on. Trouble, that should be troubled, not trouble. Troubled or failed IT projects. What can happen when a project goes south. And preservation and discovery of electronic files, which is just in the 20 years I've been acting as an expert witness, it's become a massive issue in a big field. Okay, unauthorized access. Congress, in its wisdom, Congress always passes really bad IT legislation. Let me just say that right up front. DCMA was a bad idea. The CFAA is a bad idea. I mean, there's some good ideas or nobility under there, but it's always awful by the time Congress gets done with it. This was passed in '86, so 30 years ago. And it's been expanded in scope. It's been modified. It's very broad, very vague, and you can have harsh penalties. How many of you know who Aaron Swartz was? Okay, a few of you. Aaron Swartz was this idealist who felt that academic articles shouldn't be behind a paywall. So he set up a server to basically pull them from, I believe, MIT and put them out on a public area. He was arrested and threatened with 35 years in prison for doing this. He committed suicide. The CFAA is overly broad and very dangerous if you're tempted to poke around, even in your own employer systems, maybe especially in your own employer systems. In places where you don't have authorization to do so, you're doing it at your own risk, because if you leave your employer on less than good grounds, or even if well after the fact the employer decides to come after you, they'll drag this up and say, oh yeah, he was accessing these systems. He didn't have authority to do so. We want to press for criminal charges. Be very, very careful. You know, we have a lot in the media that sort of idolizes, you know, hackers and doing intrusions and back walls and so on, and it can land you in prison with grossly disproportional sentences. Be aware of that. So be careful and aware of where you go and what you do. And of course, if you're breaking into systems that are not, you know, true confession. Back, we're talking 30 years ago, when everything was dial-up modem and so on. I used to do war dialing. War dialing was where you set up a little program that would simply call numbers in sequence, and if it hit a modem, it would connect, and then you'd try to get through and see what you found out. This is basically, how many of you have seen War Games with Matthew Broderick? Yeah, that's basically what he's doing. He gets on the Whopper, okay? War dialing is a real thing. My wife, in the early days of Wi-Fi, my sweet wife, we would be traveling to a city. She'd go with me on business trips, and she'd want internet access. And she'd pop open her laptop and look for unsecured Wi-Fi points. And this is back in the early days of Wi-Fi when hardly anyone was securing their points. So she'd say, oh, there's one. It's strong enough. I'll just use it for my Wi-Fi. Okay, that was actually illegal under the CFAA. So the point is, be very careful what you do. Yes?
Why is that illegal?
Because you don't have authorization at someone else's computer. Broadly defined, expanded scope.
So even though you no password.
Even though the password, if it's someone else's and you don't have authority to use their access point, it's illegal. That's one of the reasons why when you have public Wi-Fi, it usually comes up first with a splash screen that says, here's terms and conditions for use, so on and so forth. It's usually just not generally accessible. Now some places, they simply say, here's a password, and you can do it. And since they publish a password, and they've got it, 2 Jack's Pizza or whatever, you can get the password to log on. They're basically giving you permission. But if you're simply finding, it may be fun and amusing to access your neighbor's unsecured printer and print stuff out. There was a whole sequence of pictures a few years ago of someone who did that and started printing messages out on his neighbor's printer saying, I have seized control of your home network. And the printer ended up on the curb with the trash. But the people are far more savvy these days to keep things secure. But be careful where you do and what you go. Intellectual property. This is a multi-trillion-dollar industry. And you have organizations, the MPAA, IAA, basically all the media producers have big industry organizations who will come after you tooth and nail if they think you've been downloading movies illegally, downloading music illegally. But there are more issues than that. There's issues of using software without a proper license, violating copyright for various reasons, theft of trade secrets, and patent. I have done expert witness cases in all those areas. And the short point is, you may be tempted, oh yeah, I can get all the latest movies streaming online. Yeah, well, if the MPAA tracks down your IP address, you may find yourself in the midst of a lawsuit, and they will go after the largest possible charges they can. There have been some truly, truly ridiculous awards for what were actually relatively minor violations. Yes?
How is it possible to know what's, because like, for instance, some company may pay the producers with their ad income or something like that. How is it possible to know, like, if you go to some random website, whether they are legal or illegal or whatever?
I would suggest you check the website very carefully and see whether or not what they're producing is legally licensed content they can give to you. Yeah?
Is that an American law or?
Yeah, that's under American. This is all American law.
Okay, so is it like everything happening in America, or if I go to like, let's try China, like website and download something?
If you download something from China, but it's violating American copyright, and you're here in America, they can come after you here.
Okay.
Yes. just out of curiosity, hypothetically. I get it from a Chinese website. It's probably harder for them to track you, but no, it's yeah.
I'd say my biggest concern is that a lot of companies are patenting everything they can imagine.
Yeah.
And so I just, patent trolling. Like, how do you make something? Like, say you made it completely by yourself, but you accidentally tread on somebody's patent vaguely.
That's actually a very good question. If you're not making money on it, they won't care much. If you're making a lot of money on it, they will come after it. I have done a number of patent cases. Patent litigation is incredibly expensive. My patent cases tend to drag on for years. I love patent cases because I know I'm going to be supported by a given case for probably 2 or 3 years. I mean, seriously, I hate to say it that way.
Never ending story.
And it's interesting litigation. I had one patent case that I worked on for 2 or 3 years. And early on, I was retained by the patent owner. And they gave to me early on, they said, here's what the other side has produced as prior art. Who knows what prior art is? Prior art is basically, I'm not going to do a lecture on patents and patent law here, but if you patent something and someone else can show that the invention occurred earlier, at least a year before what's called the priority date for the patent, then your patent can be declared invalid. In other words, I can't go out and patent something that's already now in common use. First, the patent office will probably reject it, but even if it somehow gets patented, people will come out and say, hey, look, here's all the prior art. Okay, in this case, the other side, the litigation had already started and was well on its way, and the other side had produced what they felt was prior art. And I went through and looked at it, and most of it I could say, well, you know, that's sort of close, but no, it really doesn't match these particular claims in patent. But there were 2 or 3 that I looked at and said, and I told the lawyer I was working for, I said, that's really good prior art. I'm not sure how you're going to get past this. Notwithstanding my telling him that, I worked on a case for 2 more years, did reports, was deposed a couple times, so on and so forth. And 2 years later, the patent was declared invalid by the judge on summary judgment because of the prior art that I had pointed to 2 years earlier. So sometimes patent litigation will drag on, even when it's obvious that it's not a valid patent. Failed IT projects. Yeah, this is what you've been studying about all semester. IT projects fail. And bigger the project, the higher the percentage of failures. I don't know if anyone's got really good statistics on it because, frankly, a lot of companies aren't willing to talk about troubled or failed projects. But the usual ballpark figure is about 50% of all software projects above a certain size either are a disappointment on delivery or failed and killed altogether. Now, what happens is that you get lawsuits, and this is about 40 to 50% of my work is failed projects. The other 40 to 50% is it's about 40% failed projects, 40% IT, and about 10 to 20% miscellaneous items. Yeah.
I just wanted to clarify, are we talking size as in a number of people involved, timeline for the project, just kind of all of the above stuff?
All of the, sort of the size and complexity. So if you're talking about a project, say, above $10 million.
Okay. Oh, so maybe cost is a good heuristic.
Yeah.
Topic. Okay.
Yeah.
Is that a consequence of, you know, like the cost goes up as the project continues to go on towards failure?
The problem is once you get a project of that size, remember and we're going to talk about this in my next lecture. What are the factors that tend to lead to project success?
Someone who knows the whole system.
Okay, someone who knows the whole system, so you have a good architect. Focused. You start out small and work up from there. A small team of really good people. You build your minimum viable project and then roll it. Okay, what happens in large organizations? They put 100 people on it. They throw everything out the kitchen sink into the project, and they throw a lot of money at it. And they often don't have a chief architect or a head of QA. And this is why you get these projects that can spend not just tens of millions, but hundreds of millions or even billions of dollars and fail. It's a bit depressing. These are all things that you should be aware of by now. And this typically is referring to 2 or 3 party projects. This is typically a company hires a consulting firm to come in and either build something from scratch or modify, configure, and install something. Yeah?
So, like we've talked a lot about the failed or troubled IT projects.
Mm-hmm.
But one thing I'm curious about is why is this in the legal area?
Because if it's a 2-party project, it lands up in court. You have this is about 40% of my cases are you have a customer, a corporation or an organization, you have an outside consulting house, vendor, developer, firm, whatever. The corporation hires a development firm, says come in and build this new system or customize this or whatever. And it goes, and now he's back to the pattern. It goes up to the deadline, it slips, comes back to the new deadline, it slips again, and it reaches a point where the, well, if you read Webster Rate, that's all based on these two-party and three-party lawsuits. Patterns in IT system litigation all talks about this. So go read Webster Rate. If you haven't already, you're supposed to. Actually, you're supposed to have done it by today. So anyway, but you have a lawsuit, either the customer suing the developer because they never delivered, or the developer suing the customer because they did deliver and the customer's not paying. It keeps changing the scope of the project and so on. So, got those. Now, preservation of files. Oh man, it's been so fascinating to watch this over the last 20 years. When I first started doing expert witness work 20 years ago, I would get like 10 to 15 boxes of hard copy documents, which I would then have to sort through or read through myself. And it's about 2,000 pages per box. And what you had was the advent of electronic discovery of files. Now, stop and think. I was just in Costco or Sam's Club. They had a little 5 terabyte drive for backups for like, I don't know, $100 or something. I mean, guys, when I did Sundog 30 years ago, we used 140K floppy disks. It's the amount of data floating around an organization is staggering because storage is so cheap. And what you have is when litigation starts up, or if there's even a possibility of litigation, there is a legal duty to preserve all relevant documents. So if your boss comes to you and says you need to start deleting your emails, get it in writing. A lot of companies will have policies that say all emails must be deleted after 30 days. Let me tell you, as someone who has done a lot of failed project cases, you know what my absolute favorite documents are? Emails from engineers. You know why? Because engineers always tell the truth. To each other, or to their managers. This project sucks! I literally read an email that said, I can't believe we're charging the customer $100,000 for this garbage we're delivering. Luckily, that was an email on the other side. I was representing the customer, and that was a consulting firm. And their lawyers tried very hard to keep that from being admitted in evidence, and they lost that. And there were about a dozen emails like that, and they ended up settling before it went to trial because they didn't have much excuse. There is a famous case that occurred about 20 years ago where this really became an issue. Oh God, American Home Products. It was a company that made the fen-phen drug that turned out to cause pulmonary hypertension. And they had a backup policy in place in writing to cycle through backup tapes of their hard drives. And so they would have like a 4-month rotating set of tapes. So they only kept the last 4 months for any given time. Well, they entered in litigation and they failed to tell the IT department to stop rotating and writing over the backup tapes because they had documents and emails and so on. And when this came to light, the judge issued a finding of spoliation against American Home Products, which means he instructed the jury, you are to assume that they deliberately destroyed evidence that would be prejudicial to them. So ever since that happened, and basically I think American Home Products ended up going bankrupt as a result of the case. They lost everything else. So this is, if you want a physical equivalent of this, most of you are probably too young to remember. There used to be one of the big, it used to be the Big 8, then it was the Big 6, and the Big 5, and the Big 4. I worked for one of them, Pricewaterhouse. One of them was Arthur Andersen, big consulting firm. And they were the audit people for Enron, a big energy corporation. And when Enron started to go south, partners within Arthur Andersen started having people shred documents. It wasn't even electronic, they were shredding physical documents. And they were caught doing this, and the organization was literally disbanded. Arthur Andersen ceased to exist. The legal, and because it's a partnership, all the partners share both economic and legal liability, and basically wiped out one of the big, I think they're down to big 6 at that point, consulting firms. So, be very careful about your employees' retention policies. And if you hear any rumblings about lawsuits or litigation and so on, be very, very careful, both about what you write. You know, don't be the engineer who says, "Yeah, we're shipping the customer garbage." You know, if you want to say something like that, say it in person. Don't put it in an email or a memo or something that can be discovered.
Need to know amateurs.
Yeah.
This is not
legal.
Now, let me back up, because there's one issue in this one, because I did this primarily for the IT department on campus. I should have one more slide in here, because it's one of the most important, which goes back to intellectual property, but it's intellectual property with your employer. When you take a job, you should very explicitly ask about what your employer's intellectual property policies are. They may make you sign an intellectual property agreement. They may want the rights to anything you develop on your own time, because they'll claim, well, you're benefiting from the interaction with people here. What you don't want to do is develop something on your own time and then try to take it to market and have your employer sue you and say, we own that. You especially don't want to do that if it actually is derived from intellectual property of your owner, of your employer. Yes?
So that own time means 40 hours in the company, or just like the 3 years that you were there?
But what I mean is, if you're going home nights and weekends and you're writing your own program.
And they will claim that they own that.
Some companies will claim they own it. They'll claim they own anything you develop. That's why you need to clarify this ahead of time. Yeah?
I know one thing that some companies use is anything that you develop on your work computer.
Mm-hmm.
So like if you use your computer that your company gives you, then we'll be like...
Never do that. Never. If you're doing stuff for yourself, never, ever, ever do it at work.
Well, not
Or
even
on work, yeah, or on work computers,
Right.
like your work laptop or whatever. Just don't. Again, I have litigated these kinds of cases. Yeah.
I was going to mention, because actually my dad, he's a lifetime engineer, but he took a job, he negotiated with them to have intellectual property rights to stuff he made outside of it.
Yep. And that's what you can do. You can negotiate, particularly if you've got something already developed or under development. When you go there, say, by the way, here is something which I have been working on and I already own, so let's put a flag or a memo here that says, this is stuff I have worked on or anticipate working on, and we will mutually agree that you don't own that, and I will agree that I will not do this on company time or on company equipment. So that's, just be aware of that, because I have seen innocent, well-meaning programmers really get shafted over intellectual property issues like this. A similar issue, which I also didn't cover in this slide because it wasn't originally geared towards programmers, I need to update it, is non-compete, which is a lot of companies will want you to sign a non-compete agreement. And they will make this as favorable to them as they can. Basically says, okay, you're coming to work for us, we're doing word processors. When you leave us, you can't work on any word processor for 3 years. Now, what's the problem there? That's going to be your expertise when you leave. So, and the thing about non-compete is it varies by state. It's not a federal issue, it is a state issue. One of the reasons why tech is so hot in California is that the California judiciary, in essence, decided 20 or 30 years ago, we're going to be very, very liberal when it comes to non-compete restrictions. We're going to say that, you know, it's very hard to restrict anyone. And this is why people can move from company to company in Silicon Valley, and boy, unless they are really taking with them honest goodness trade secrets or intellectual property, it's very hard to block them. On the other hand, there are states in the Midwest that I've seen uphold 5-year non-compete agreements for programmers. I mean, that basically says I worked in this area and I can't work in this area for 5 years. Yeah?
So if a company wanted to be able to copy someone else's thing, they could have a part of their base in California and a part of it in like Seattle or whatever, and then would they have to work on the...
It depends on where you're actually employed, because it's going to be a state law issue. Yeah?
So my husband works for Microsoft's cloud.
Azure, yeah.
Azure. And I work for Amazon's cloud service. Would that create a problem?
For who? Technically speaking, no, it shouldn't, and it would be hard pressed for them to preemptively constrain the employee. But on the other hand, they may basically say, if we have any reason to suspect that you are passing Amazon secrets on to Microsoft, or, you know, we're going to come after you, and Microsoft might tell your husband, okay, if we think you're passing Azure secrets on your wife, we're going to have to. So you potentially have that, but it would be hard pressed to simply. They would have to ask, find out, and then refuse to hire one or the other as a basis on that. And you know, most of it is sort of right to employment, so they could simply choose to do that and consider too great a risk. So, Ben?
Yeah, I was wondering what happens if, like, say you work for a company in the Midwest that has 5-year, like,
Non-compete.
non-compete agreement, but then you move to a state like Washington or California.
They'd sue you back in the Midwest. And they'd sue you back in the state you were in, and then if they could win the jurisdiction back, then it would be according to whatever the state's rules were.
So then, in this hypothetical situation, say you just don't want to work for this company anymore because you don't like the manager.
Yeah.
So then you just out of work for 5 years and have to like be like a bum.
Well, you could go work in other areas. The non-compete would have some very specific things. In other words, if the company is doing accounting software and they have a 5-year non-compete, basically you have to go find other fields to work in than accounting software for 5 years. And of course, the companies are going to try and claim as broad an area as possible. So that's something else to be very aware of. When you get hired, ask about intellectual property, ask about non-compete on termination, and make sure you understand what the issues are. Yeah.
What about internships?
Well, that's a good question. I don't know what they make you sign for internships.
Yeah, I still have to find something.
Yeah.
It didn't last long enough to like
Yeah.
affect me, but.
Yes.
On the topic of spouse, it says, in any marriage, private information is often exchanged between spouses. If either you or your spouse is a defendant in a court trial, the husband-wife privilege prevents the confidential communications from being used as evidence against you or your spouse.
Oh, there you go. Well, yeah. your
But
spouse-
that would be good liability to not hire you
Yeah.
because of that.
Anyway, so that's my advice. I know. How many of you already have jobs lined up? Okay, I'd go back and look, and if it isn't, I don't know what all they had you sign, but if they didn't have things specific about non-compete and intellectual property, I would get that clarified. Likewise, for jobs you're interviewing for, those are issues to bring up. Just to say, by the way, you know, we've talked about this in my classes. You know, what's your policy on intellectual property? What's your policy on non-compete? And make sure you know that. Okay, let's take the roll, and then we'll do the last lecture, and then we'll let you out of here. Turn the lights on so I can actually see what I'm doing. Hey! And everyone wakes up.